Again, our training today is brought to you by our partners over at San Bernardino County. And today we are so pleased to be joined by two of our representatives. So we have Carmela Giliberto, Business Services Specialist, and Angelica Villaseñor, Business Services Representative, who are here to share more about the resources available to employers like yourselves. Good morning, ladies.
Yes, good morning. Thank you, Anna, and thank you everyone for being here today for this highly informative monthly workshop brought to you always by the engaging speakers of CEA. It is my pleasure to introduce our Business Services Specialist, Carmela Giliberto, who will shortly be sharing some of the services we provide. As you see in the flyer for workforce development, we provide multiple services, and we have 3 job centers. One that is located here in the city of San Bernardino, another one in Rancho Cucamonga, and one in Victorville. We also host a variety of job fairs. So if you are in need of hiring, please let us know. A popular service is our on-the-job training, or OJT. With WIOA funding, we can help assist businesses' hiring needs, and we reimburse up to 50% of the wages for a period of about 3 months while training the employee in his or her new job. We still have funds, so let us know. Reach out to Carmela or reach out to me. Please take advantage of this service. And we also have our workshops just like this one. So as Anna mentioned, she dropped the link. So please register, and we will see you at our next workshop. And I would like to introduce Carmela Giliberto so she can explain some of our other fascinating services we provide. Thank you.
Good morning, everybody. Thank you, Angelica. As a business service specialist, I work with business consultants who help businesses in need of funding for needed business improvements, such as incumbent worker training, social media marketing, leadership training, etc., to increase productivity and therefore prevent layoffs. A program we recently rolled out, and I'm really excited about, is called the Transitional Job Program. Think of it like a part-time paid internship where the county is the employer and will provide the business with candidates for your consideration for up to 320 hours from our database. It's a win-win. You get additional help while giving our unemployed job seekers the opportunity to gain work experience. So if you're interested in that, please let us know. I'll put my information in the chat. Want to save money? Remember, take advantage of our complimentary HR hotline, 1-877-282-3763. We also have an employer toolkit where you can have access to various resources, as well as links to our partners in San Bernardino. So save our website, workforce.sbcounty.gov. This will give you access to our calendar of workshops and future events, job fairs, etc. So again, interested in any of these services, please feel free to reach out to us via email, phone call, or better yet, even come visit one of our job centers. Thank you so much for your time. Without further ado, I'll give you back to our beautiful Anna and our fabulous speaker, Juliana.
All right. Thank you, Carmela. Thank you, Angelica, and your entire team for all that you do for employers in your county and beyond. So now I'd love to introduce our trainers today. We have Juliana Gabriel, our Senior HR Compliance Director, who will be leading our presentation. And then Mary Bradford, our Senior HR Director, will be supporting us in the Q&A. So you are in great hands. And Juliana, it's all yours.
Thank you. And thank you again to Carmela and Angelica. We're very excited to have you join us this morning. I would like to introduce California Employers Association, or CEA, for those of you who are maybe joining us for the first time. We are the voice behind the HR hotline. So when you are calling in, you're getting a CEA HR advisor, such as myself, Mary, or one of our colleagues to answer your questions. Now, if you find you do need some additional support beyond that HR hotline, you can join us as a CEA member, and that gives you access to our extensive library of resources, including HR forms and toolkits that you can use in your day-to-day practice. We can also help you out with projects. So if you need help customizing or updating an employee handbook, providing some training for your staff, like harassment prevention training, or maybe assistance with your own internal workplace investigation. We can help out with all of those types of services. So you can visit our website at employers.org. You're also welcome to call into us directly with any questions that you might have. Now, I do want to remind you that the presentation today is for educational purposes only and should not be relied upon as legal advice. So if you do have an issue of legal significance that's particular to you, make sure you consult your own attorney about that. But that said, we're more than happy to answer general questions about the content today. So as Anna mentioned, Mary's going to be in that Q&A box the entire training, answering questions live. So please take advantage of that. All right, so let's talk about what is on our agenda today. There's a lot to consider with workplace investigations in California. And so we're going to give you an overview of when you're obligated to conduct a workplace investigation in California and recognizing some of those triggers when you might need an investigation. As we're going to learn, conducting workplace investigations is really an art form. I do encourage you, if you ever have an opportunity to shadow someone who's done investigations and their experience in that area, take advantage of that. But we're going to give you some really great fundamentals and options to consider when you're conducting your workplace investigation, from things like selecting the best investigator, how to plan the investigation. You know, are there any temporary personnel changes that you might need to make while the investigation is pending? Witness interviews. How do we conduct effective witness interviews and make assessments of credibility? We'll talk about how you reach your conclusions. And then finally, really the whole point of your workplace investigation is stopping bad behavior, right? So engaging in prompt corrective action if you do find that there are policy violations. So let's start with our overview of where our rules come from, and that is California's Fair Employment and Housing Act. You're going to hear me refer to this today as FEHA. So this is our law that deals with harassment and discrimination issues in the workplace. And one of the requirements is that employers have to take all reasonable steps to both prevent and promptly correct harassing or discriminatory conduct. And that includes this obligation to conduct a fair and thorough workplace investigation. Because a lot of the time we get an allegation or a complaint and we don't know one way or the other what's happened, right? We have to get to the bottom of it and find some resolution. Now, the standard when we have to conduct a workplace investigation is anytime the employer knew or should have known of alleged harassment, discrimination, or retaliation. So we're going to talk about some different ways that might come about and trigger a workplace investigation. Now, if you do meet that standard, you have an allegation of harassment or discrimination, for example, then you have to conduct an investigation that meets all of FEHA's requirements. And we're going to go into these in detail today, but just so you know at a high level what that means. That investigation needs to be conducted in a timely manner. So this is not something that we can sit on. We have to move swiftly. It needs to be thorough, meaning detailed, and objective, meaning fair. So we shouldn't choose an investigator that's somehow involved or has a bias, right? And then a lot of people are surprised to learn that part of that fairness is we have to provide the accused person the opportunity to respond to all allegations against them. So while we don't have to identify necessarily who complained, they do get a right to respond to the allegations and tell their side of the story. Then we need to include a well-reasoned conclusion supported by evidence, meaning we're pointing to facts to support our findings, right? Not just opinions. We have objective factors that we're pointing to, we're documenting that. And then finally, it's resulting in prompt corrective action as appropriate. Now, really important to keep in mind, there's some very strong anti-retaliation protections. So what that means is when someone brings a complaint of harassment or discrimination, it's important to remember that they cannot be disciplined for that, demoted, terminated. They can't have any sort of adverse employment consequence because they complained, or maybe they didn't complain, but they were a witness that participated in an investigation and provided information. They can't face any sort of negative consequence as a result of that. And you also want to be careful of the appearance of retaliation. You know, let's say you have someone and they're having performance issues, and then they bring a harassment complaint, and then that's the time you decide, you know what, let's go ahead and end their employment. It could look like you retaliated against them because they brought that harassment complaint, right? So we want to be thoughtful when we are choosing the timing of those decisions. It's also important to know that employees are protected even if the conduct complained of wasn't actually unlawful. So as long as they brought that complaint in good faith, even if you ended up finding there was no policy violation, they should not be retaliated for that. And you want to be thinking about, we want to incentivize people to come forward and bring forward concerns and complaints. That gives us as employers an opportunity to potentially rectify it and resolve it. When we don't do that, we kind of turn a blind eye. That can lead to more people maybe feeling like, well, I do need to go hire legal counsel, or I do need to go file a claim with the Civil Rights Department, right? So it's a good thing when people come forward and bring their concerns and give us an opportunity to address them. Now, we would recommend, although FEHA is related to allegations of harassment or discrimination, it's a best practice to also investigate other serious policy violations or allegations of those policy violations. So things such as bullying or abusive conduct. So if someone's being targeted with ill intent, even if it's not rising to harassment, it's not based on a protected class like race or gender or disability, maybe it's just a personality conflict. We still don't want that type of behavior in our workplace, right? It's likely a violation of our code of conduct, and it could eventually spiral into a potential harassment complaint. Workplace violence. So as of last year, this is a new requirement for most California employers. It's outside of FEHA, but what is required is that you do investigate any allegation of workplace violence or threat of workplace violence. And we do have to document that on what's known as a violent incident log. So be aware of that separate requirement. And that can include things like sexual harassment are considered workplace violence under the law. What else? Fraud, stealing, ethical violations. And a lot of the times employees might use some of these terms interchangeably. They might say they're being bullied, but really what they mean is they're being harassed based on a protected class. So we should always kind of dig in further to see what exactly they're alleging, so we know if that's triggering a FEHA investigation where we're required to meet those components that we just talked about. So I think the best way to learn this is to jump into some hypothetical scenarios and kind of bring it to life. So you have an employee, they're complaining of a hostile work environment. So we already have kind of this buzzword indicating that harassment might be going on, right? So you question the employee and you learn that they're alleging that their supervisor is strict about employees' attendance issues. And they're not really alleging any sort of abusive conduct or bullying, just that their supervisor is very strict. And you independently review timesheets, you talk with the supervisor about the attendance issues, and you confirm that that strictness is applied evenly across the board, right? And so you find that there's actually no policy violations here. So this doesn't trigger a FEHA investigation, but we should still have some level of documentation, right? That we looked into it, we closed the loop on it, we found that there was no policy violations. Now, what if the scenario played out like this though? You question the employee, and this time they're alleging that their supervisor is strict only about certain employees' attendance, and they're claiming that the supervisor is favoring male coworkers, allowing them to miss work or show up late. Now, at this point, we don't know if this is true or not, right? And there might be some sort of justification. Maybe these male coworkers have a medical issue or a reasonable accommodation. So we don't know one way or the other right now. But this is an allegation now of possible gender discrimination, right? People being treated differently on the basis of gender. So this does trigger our obligation to conduct an investigation that meets all of FEHA's requirements. And also, I find it really helpful if you are at all involved in investigations at your company, I would recommend taking a look at the Civil Rights Department's Workplace Harassment Prevention Guide. There's a lot of really great FAQs on the workplace investigation process. And this is the agency that has enforcement authority over these issues. So we've incorporated a lot of that information in this training today, but sometimes it's good to just go see it directly from the source. So I would encourage that. We have a bit.ly link here for you. You can put that right in your browser and take a look at that. All right, so let's talk about this new or should have known standard. So anytime any supervisor or manager learns about an allegation of harassment or discrimination, they have an obligation to escalate that to someone who is going to investigate that. So maybe that's your HR department or your management team, right? And it can come up in a number of different ways. So the most straightforward is you receive a employee complaint, right? And it's a formal complaint that says I'm, bringing a harassment complaint. So that one's obviously very apparent. But a lot of the times it happens more informally. You might have an employee that's just venting to their supervisor or complaining about something that's been happening. And supervisors, a lot of the time, will make the mistake of saying, do you want to bring this to HR? Or do you want to file a formal complaint? And it's not up to the employee. That's not the standard. It's whether you knew or should have known that that was maybe happening in your workplace. And so once the cat's out of the bag, so to speak, the supervisor has to escalate that. They don't leave it up to the employee whether that moves forward. So make sure you train your supervisors on that. Anonymous complaints, we have an obligation to investigate these as well, according to our Civil Rights Department. So we just have to do the best we can with the information that we have available, so we can start, calling some employees in to talk to them and get a sense of what's maybe going on in the workplace and see if that leads to anything. Now, even if nobody's complaining, we might observe the conduct. We might see something or hear something that we believe is a violation of our policies. That would trigger our requirements. Rumors and gossip. So even if you don't know where that rumor originated from, if true, it would be harassment or discrimination, if that's kind of what's being alleged in the rumor, then we need to look into that. We need to follow up and investigate that. Also, complaints from former employees. So I've seen companies make the mistake of saying, well, the person's complaining that they were uncomfortable, but now they're not here anymore. Maybe they brought this up in an exit interview or after the fact, and so there's nothing that we need to do about it. And that's not correct, because even though that person's gone, you never know if this type of behavior might be happening to other employees in your workplace. And so you still want to investigate and look into that. You don't want an argument that it was brought to your attention and you never looked into it, and then others, were harmed as a result of that. And then also administrative charges or lawsuit, kind of in a worst case scenario, you might receive information that way. When that happens, I would recommend consulting legal counsel about the best strategy for how to move forward in that case and look into those issues. All right, so let's jump into another real world scenario, and I'm going to ask you for some feedback. Harold is the shift supervisor at a bar. In the back, outside the earshot of customers, his employees regularly engage in banter about the attractiveness of the customers. Harold has noticed that one of his employees, Randy, sometimes gets a funny look on his face and pulls away from the group when this happens. As Randy's supervisor, what should Harold do? So go ahead and get ready in the chat box, and you have some choices here. Are you saying A, this is just friendly, innocent interaction among coworkers? Harold doesn't need to do anything about it. It's not directed at Randy. B, when this happens, Harold should go up to Randy in front of the other employees and tell him to lighten up. He works at a bar. Or C, Harold should find a time to talk privately with Randy about what's going on and find out if Randy is uncomfortable. Let me know what you think. It looks like we have unanimous votes here of C, and that is correct. So let's talk about how this might play out. So yes, we do want to talk privately with Randy. We don't want to call it out in the moment, right, in front of the other employees. And we want to find out if there's maybe anything else that's been said, right? We might know that they're rating employees on a scale of 1 to 10, but we don't know if maybe they're having conversations of a sexual nature, talking about private body parts, right? So that could be a violation of our harassment policy. And it can create a hostile work environment, even if it's not directed at Randy. If he's having to listen to that every day, right, it's making him uncomfortable, that can lead to a harassment claim. Now, let's say it is just this rating system and it hasn't gone beyond that. We should still probably instruct our employees from refraining from making these kind of comments about customers' personal appearance. It probably violates our professional code of conduct. It would be bad for business if our customers found out about it. And we just never know when that conversation might start to take a turn and kind of devolve and then ultimately lead to claims of harassment. So we want to keep that good professional work environment. And then we don't have to worry about if someone, being made uncomfortable. All right, now let's say you have an employee come to you and they bring a complaint and it takes you off guard, right? They kind of drop this bombshell. If it's never happened before where someone's brought a complaint to you, you might not know exactly how to respond in that situation. And so we do have some sample responses for you that really show that you are going to take it seriously. You're going to respond immediately without commenting one way or the other on what you think is occurring, right? And so you can say things like, thank you for coming forward. I know this isn't always easy, right? So you're kind of validating their feelings, but you're still not necessarily siding with them. So it shows that level of empathy. Now, if you think someone's going to divulge something that they don't want investigated, right? As I mentioned, once the cat's out of the bag, we have a responsibility to respond. You could say something like, before you start, please know I want to help you, but you should know that the company is required by law to investigate certain issues. So you can kind of give them that last heads up. I want you to know the company takes any and all harassment complaints very seriously, and we will start an investigation immediately, right? It's letting them know what that next step is going to look like. We will keep everything about this complaint as confidential as possible, meaning we share information on a need-to-know basis only. So make sure you don't fall in that trap of ever promising complete confidentiality, or it's an off-the-record conversation, because as part of our investigation, we might have to talk to witnesses with knowledge. As we talked about, the accused person has a right to respond to the allegations, and we might need to also discuss it with our management or our HR team on how we want to proceed once we have our findings. So that's why we want to say we will keep it as confidential as possible. All right, so let's talk about the timeline to initiate and also complete an investigation. So as we talked about, a complaint requires immediate attention. And according to the Civil Rights Department, they say an investigation should begin within a day or two as a best practice. So once you receive that complaint, look at it kind of as a 48-hour clock that starts ticking on when that investigation should begin, meaning that we're speaking with the complainant, right? Now, we also, though, need to resolve it in a timely manner. And I've seen that mistake be made where the HR professional will be really good about starting that investigation promptly. They start interviewing people, and then when it comes time to come to their findings, they kind of get stuck and they kind of just sit on it because they maybe don't know which way to find. But what our Civil Rights Department says is we should strive to complete an investigation within 2 weeks. So we should basically be reviewing evidence, interviewing people, and drafting that report. It's kind of like boom, boom, boom. That can obviously vary depending on how many issues are involved. I'll say on average for me, I'm pretty thorough with my reports. So I average more towards probably 2 to 3 weeks on average. And also it can be longer depending on things like witness availability or the number of issues involved. So I've had a scenario where the complainant gave a written complaint, and then they immediately went out on a leave of absence and they were unreachable. And it was really important to talk to the complainant, right, to get to the bottom of the issues. And so I made that judgment call of seeing, well, can we get that complainant when they get back from leave, right? But that's why I said with investigations, it is kind of an art form. We do have to make sometimes those tough judgment calls. And we don't want to put expediency above completeness, right? We don't want to just check our box and say we're done with this investigation if there's still other really relevant information that we should consider. All right, so one of my employees just told me that another employee said something that really upset her. I told her that I was really disappointed that her coworker would say such a thing, and that the coworker would be disciplined for saying that to her. Was this the right thing to say? And you might recall that was not on our sample responses, right? So when you get a complaint like this, we don't want to assume that what the employee is telling us is accurate. And we also don't want to make any sort of guarantees or promises, right? The whole point of a fair investigation is that we're keeping an open mind. We're doing our due diligence before we come to a conclusion. And this could actually also be viewed as an admission on the part of the company if there was later a lawsuit, like you said that this happened, right? And you said that they would be disciplined. It could be used against us. So we'd want to revert to one of our phrases, thank you for bringing this forward. We're going to look into this immediately, right? Those are better ways to respond. All right, what about this? I heard in passing late Friday afternoon about a possible harassment incident. Next week is our annual inventory. Can I wait until the following week to investigate? And as we said, no, this is not a good idea, right? To wait another week. Even if you're extremely busy, you need to make time for an investigation. And as we'll talk about in just a minute, in California, you can hire a third party, an outside party, to come in and handle it for you in the event that you're too busy. So you could get the process started on that instead. All right, so let's talk about, are you the right person to conduct an investigation? Maybe you've been tasked with this at your organization. And I think there's really 2 questions you should ask yourself initially. Number one, am I competent to do this? So our Civil Rights Department says that those that conduct a workplace investigation need to have knowledge about investigatory requirements, experience, and training. It doesn't have to be any sort of professional training. There's no specific training, but they want some level of training. And so that's why I say, if you can shadow someone, do that. Now, not all of us have that luxury. Some of us are at smaller businesses. We may not even have an HR department. I do have a resource for you at the end of this training for some more practical hands-on experience that I'll talk about. But step number one is, do I feel like I am competent to handle this? Question number two is, do I have any actual biases that would interfere? So for example, have you gotten maybe a little too close to someone that's involved in the investigation? So I would say, as a rule of thumb, if you are friends with someone on a personal level, maybe you text on a personal level, or you get together outside of work and they are now involved in the investigation, you should probably be transparent about that with your supervisor, your management team, and say, I really don't think I'm the best person for this. I need to recuse myself. Because even if you think you can be fair, there's that perception of bias. And you want to be thinking about, that lens of, if this were in a lawsuit down the road, is someone going to try to attack my integrity? Am I going to give them a reason to do that? So be thinking about it that way. And then also, you might want to ask, does the accused party or complainant have more authority in the organization than you do? If you report to that person that's the complainant or the accused, there's an argument that you're biased, right? Because they have sway and authority over your employment. And so in that case, it's probably best to get a third party. And then, do you need any sort of special expertise? Are there overlapping issues? Maybe there's also wage and hour claims and you feel that that's not really your bread and butter. Maybe we bring in someone that has more experience with all of that. All right, so now let's say you don't have an employee internally that makes a lot of sense to conduct the workplace investigation. California does say you can bring in a third-party investigator to handle it for you. Now, in that case, the investigator must be either a licensed attorney or a licensed private investigator, a PI. So those are your two choices in California for third-party investigations. And CEA does have licensed attorney partners that we can refer you to that can come in and do that investigation from start to finish. So you can reach out to us if that is something that you ever need. All right, so we're about halfway through the training and we've gone over those fundamentals of an investigation and what triggers an investigation. Now we're going to get into kind of the nitty-gritty of investigation planning and how we carry that out. So we're going to talk about some temporary personnel changes that you might want to consider while that investigation is pending. What evidence do we want to look at and how do we gather that evidence? And then a really important component is preparing those witness questions, right? And getting ready for those interviews. So let's talk about things that you might want to do in the interim while the investigation is ongoing. So kind of before you even start, some things to consider. Number one is anyone in danger? So if you have a complaint that involves an urgent threat of workplace violence or sexual abuse, something along those lines, you might want to consider getting law enforcement involved, right? And also reaching out to them. Hopefully, we're not in that type of situation, but you might still have a complainant that's still very highly emotional. They might say, I cannot work with this person, or I can't work with my supervisor right now. And so while that investigation is ongoing, before we've gotten to the bottom of it, you might consider something like a temporary reassignment to a different department, shift in schedule so people are not overlapping, or maybe they're working in different offices or work areas, or a temporary change in the reporting chain, especially if it's between an employee and their supervisor. Now, that said, it's kind of a balance. We have to be careful that we do not retaliate, or there's the perception that we're retaliating against the person that complained. So we don't want to do things like say, well, why don't you just take a leave of absence while this investigation is pending? Or we're just going to cut your hours, or we're going to put you on the night shift now, right? That could all be viewed as retaliation. So we want to try to avoid that, where someone is put in a worse position or their hours are cut, anything like that. Now, something else that you can consider, especially when the allegations are pretty serious, if it is something like sexual assault or workplace violence, what you can do is you can consider placing the accused person on a paid administrative leave. That's often seen as a best practice. because if they are dangerous to your workplace, we don't know one way or the other at this point, but you're removing them as a potential threat to your workplace, but they are also not suffering a loss in wages. They're being paid during that time. So it's seen as kind of striking that balance. Now, that said, all situations are different. So if you're questioning what's the right approach, you can always consult legal counsel, get some attorney-client privileged advice on what you should do in your particular situation. All right, and then really our next step is gathering evidence. And this comes usually before we start talking to people. It might come after we talk to the complainant, but why we want to do that is that there might be things in documents or in surveillance that's going to inform what questions we want to ask of our witnesses. So I would say 9 times out of 10, I am starting with this step in the process. And it's really important that we're clear on what the allegations are as we're gathering evidence, because that's really our scope of the investigation. So we do need to have an understanding of that. And that's why I said you may talk with the complainant first, at least initially, and then have a longer interview with them. Also really important, even if the complainant submits a written statement, we want to have an interview with that person because there might be details that aren't in that written statement. It can also help us assess whether they're staying consistent with their story. So always do have that next step. Now, something to keep in mind as you're reviewing different documents and information, the law is clear that it's not what's known as a fishing expedition, right? We're not in the FBI, and we do have to balance kind of our employees' reasonable expectations of privacy. And so I don't recommend, demanding that employees turn over their personal cell phone records, for example. I think probably a lot of the times that's a bridge too far. Now, if there's information on company devices and we've alerted them in our policies that we have a right to review those company devices and emails at any time, then it could be fair game, right? So we do want to take into account employee privacy expectations. Now, what are documents that we want to review in every investigation? So with every investigation, I first start with our handbook policies. Because that's really what we're evaluating is whether there was a violation of policy. We're not making an assessment of the law. We're looking at our particular employer policies. So I always start with that to see what they say. And then I always want to see personnel files, definitely for the complainant and the accused, maybe even the witnesses involved, because that can kind of tell a story, right? If the accused has had a pattern of violations in the past, it doesn't necessarily mean they've done it again, but it could be evidence to suggest that, it's an ongoing issue. On the flip side, with the complainant, do they have motivation to bring a complaint right now? Maybe they were having performance issues, right? And this was their way of kind of trying to avoid being terminated, right? There's a lot of different factors that we might find in those personnel files. Some other information include pictures or videos or surveillance, especially if there was an incident that happened in the workplace and you have surveillance, that can be really helpful. And we can ask our witnesses about that surveillance and say, explain to me what was happening here, right? On company devices, phone calls, email records, computer files, time card entries are sometimes relevant if we're trying to figure out if people were there at the workplace at the same time, right? Overlapping issues. So it's really, really broad and it can depend on each investigation. All right, now here's a really important step. We've gathered our evidence. Now we need to get ready to conduct those interviews and we want to prepare our investigation questions. And especially if you're a newer investigator, but I think really any investigator can be benefited by making an outline in advance of the questions you want to ask or the list of topics. It can really help keep you on track to make sure that you've covered everything that you want to. And then also, if you do have a witness that tends to go off on a tangent or try to kind of derail the meeting, it really helps me at least bring it back to focus and see, did they answer my question, right? That said, you don't want to look at it like a script. So you don't want to read it word for word because when you're in an interview setting, you really want it to feel natural and conversational. I think that's really how you're going to get the most out of it. So we need to be able to kind of pivot when necessary, right? So I would view it more as a checklist. Also, you should try to draft your questions in an open-ended way so that someone can kind of just tell their story. So you can say something like, tell me about what made you uncomfortable last week, right? And then they can talk and they can just give their story. As opposed to a question like, is it true that Jerry walked into your office last week and touched your shoulder in an inappropriate way, right? That's going to be a yes or no question, and you're not going to get as much out of that. And so I had a practitioner at the beginning of my career say, look at it like a funnel, right? Where we're going to start with these really broad questions and see what we can get out of that. And then if we're not getting the information that we need, then you can start drilling down into those more narrow questions to get your answers. Another really useful tool, I use this all the time, is for each allegation, and I write this on my outlines, we want to answer who was there. That's going to tell us our potential witnesses. What happened? So what are the specifics? When did it happen? Where did it happen? And then why it happened. So, someone might say, I believe I'm being treated this way because of my race or because of my gender. That's really important, right? And I would also ask anything else, anything I didn't cover, anything I missed. So the who, what, where, when, and why questions can be really helpful. And then try to keep an open mind, right? We don't want to start off with a suspicion or a conclusion that we work backwards to try to prove. I've had some situations where the complainant was really convincing at the outset, and I thought, oh, this is probably how the investigation is going to go. It's going to be fairly straightforward. And then I started talking to witnesses, and it turned out to be the exact opposite, right? So we have to keep that open mind. And then also in your notes, address the credibility of your witnesses. So if they're making inconsistent statements, if they're not making sense, right? Take note of that, because you might need to take that credibility into account as you make your findings. We also do want to create a witness list. And our initial witness list might change, right? We might add people, we might take people off that we feel like we don't really need. But we're going to start typically with the complaining party. Again, this is because we need to know what's the full scope of what they're alleging, because that's what we're investigating, right? And then I would say the majority of the time, it makes sense to then speak with the accused person, because if they have different versions of events, then you can compare those different versions when you then speak to witnesses. And so then you would move out to witnesses from there. Now, I have had situations where I've done complaining party, then witnesses, and the accused last. So one example of that is when there was indication, the accused was a supervisor, and there was indication that they were trying to influence what the other witnesses were going to say. There were some witnesses that were alleging that that was happening. And so in that case, I did not want that to compromise the investigation. And so I made that judgment call of going with complaining party, then speaking to all my witnesses and doing the accused person last in that case. So again, it is an art form. There's not always a specific formula to how we should do things. We want to be thinking about, when we're choosing our witness list, who has relevant information, meaning that they, if they were there for an incident, they saw something, they heard something, right? They had a vantage point, or maybe they spoke with the complaining party or the accused party about the issue. Those could be folks. What we want to avoid is people that are just giving their opinions on someone's character. We don't really care if someone, if they think that they're a good person or a bad person. We're focused on facts, right? So we want those with relevant information. People mentioned in documents, right, that are relevant might have information for you. And then we also want to consider people the complainant asked us to interview and people the accused asked us to interview. And that's part of showing that we are conducting a fair workplace investigation, that we are considering the people that they want us to speak to. Now, that said, we're not obligated to interview every single witness named by the complainant or accused, or everyone on earth that might have relevant information, right? It could potentially be everybody at a company. Reasonable conclusion. So you can draw that line somewhere. All right, so let's talk about scheduling interviews. So how we go about that. We're going to work with our HR team or our supervisors to determine our interviewees' work schedules and availability. But that said, we do not have to explain the purpose of the meetings to our supervisors. And I would recommend, if you can schedule them like the day of, to do that. We want to give interviewees probably the least advance notice as possible, just because then that's going to be less of an opportunity for them to talk with each other or speculate about what they're being called in for, rehearse their answers, right? And I've had investigations before where the employer will call us and they'll say, you know, we started our investigation and we've given the accused person the complainant's statement. And my heart always sinks because now that investigation interview is not going to be as meaningful, right? They've been able to review it, prepare and rehearse their questions. And so we do not want to do this. We want to get a candid, spontaneous responses from them in that interview. The one exception is if you are in a union environment. Unionized employees do have a right to know the nature of the allegations against them. So not necessarily the complainant's statement, but they do get to know in advance what those allegations relate to. And they also have the right to a representative in that interview. So if you are in a union environment, there are some special considerations. So make sure you do consult with a labor relations expert on that. But outside of that, I would not recommend giving any sort of advance information. And then also keep in mind as you're scheduling interviews, the employee's participation in that investigation is compensable time. That is on the clock time that we do have to pay for. All right, let's talk about the interview location. So this one's actually a really important component, although it might seem pretty simple. But we want to conduct interviews in a private, closed door setting, of course, where others cannot hear or see. You know, we don't want big glass windows, right? And we also don't want it to be in a place where there's a lot of foot traffic back and forth, where people are kind of peering in and speculating about what's going on. That can lead to a lot of gossip in the workplace that's really not necessary. And so if you're in a smaller office, you might even consider doing these interviews off-site away from your workplace. You do have to pay for the travel time, obviously, so there's some wage and hour considerations with that. But that could be something that you consider. If you have remote or hybrid employees that have their own home office, you might also consider video chat. There's pros and cons to doing an interview that way, but that is an option that often will put people at ease when they are in the comfort of their home. So witnesses do tend to be more hesitant to speak and provide information when they feel like coworkers are kind of, peering over their shoulder. All right, so now that we're getting into that investigation interview, let's talk about how we start off that interview with our background questions. So background questions are just kind of lead-in questions. They're not having to do with the allegations. Usually they're about employment history, things like how long have you worked for the company? What are your job duties here? How would you describe the culture? Just kind of those softball questions. And these are actually really important for a few reasons. So one, you can kind of use those background questions and the way they're responding as a baseline to see kind of how willing is this person to answer questions, right? Are they really chatty and detailed? Are they more quiet? Because then when you get into the more serious questions, the substantive questions, you can see if their demeanor suddenly changes. And that can sometimes be an indication that they're being evasive or they're not being as forthcoming. If they were really, really chatty and then all of a sudden they kind of shut down and they're giving you one-word answers, right? So it can be helpful for that reason. And then also it can help create a more relaxed environment for your witnesses when you start off with these softball questions that they can kind of warm up with. You can kind of establish rapport with them. I would also recommend for witnesses that you let them know that they are not in trouble and the reason that they're being called in is because you believe they have relevant information. A lot of witnesses, even when they've done nothing wrong, are very, very nervous to be called in this type of setting. And so we do want to do our best to put them at ease if we can. And I think that reminder to them is just really helpful. Also you can just start it off by having just a normal human conversation about sports, the weather, what'd you do this weekend, right? As they're coming into the room, we want to try to create that relaxed environment. We are, again, not in the FBI. It's not a criminal investigation. So we can maintain that level of just kind of human connection. All right, so now when you start getting into the substantive issues, we have some tips for you. So we have our 80-20 rule. So we say employees should really be talking 80% of the time and us 20% or less of the time. So we're asking questions, but we really, again, we want them to be just kind of free-flowing, telling their story. Do your best, even if there's awkward pauses or silence, if they're thinking, right? don't interrupt or try to finish the question and fill in the gaps, right? Because we don't know what they're going to say. So try to avoid doing that. Try to avoid questions that call for speculation or opinion. Again, like, what do you think of this person, right? We want to stick to facts. What did they see? What did they hear? What did they discuss, right? So those are the types of questions we're interested in. Ask for clarification when you need to. You know, you will sometimes have witnesses that are very confusing, or they're giving you a story that's completely out of order. And so I'll say something like, you know what, let's kind of back up here. Let's start with the most recent incident. You know, walk me through, and then I'll do my who, what, where, when, why. You know, who was there? Okay, tell me what happened. Start from the beginning, right? And then where was this? When was this? So get them back into kind of like an organized way of responding if they're all over the place. And we do want to try to ask our questions in some sort of chronological or systematic order. That will help us get all of our questions answered. Another really important point is don't shy away from tough questions. You know, sometimes we have to ask about inappropriate statements or conduct. And the more that we show that we can, you know, ask those questions and talk about it, then usually they feel more comfortable, you know, giving that information as well. Be straightforward. We're not there to trick anyone. And then also do note some of those nonverbal cues in your notes, like eye contact, body language, right? That can sometimes be helpful towards your credibility assessment, as we're going to talk about in just a minute. All right, so now let's get into how we reach our conclusions and come to our findings. So part of the investigation process, you know, sometimes we are not going to have direct evidence on something. Sometimes it is going to be a he said, she said, or she said situation. And we do have to make a finding based on who was more credible. And this does often require more specialized training to be really good at it. But here are the factors from the Civil Rights Department, and you'll find that in that guide that I was talking about. But they say you can consider things like inherent plausibility. So basically just, is this believable on the face of it? Does it make common sense what they're saying, or does it sound kind of outrageous? Demeanor. So that's things like tone, body language. Are they making eye contact with you? Now I'll say about, probably 10 years ago, there was a lot more emphasis on demeanor evidence in investigations, where I've seen the HR community kind of shift away from that. They say, you know, studies really say that people are not as good with assessing demeanor for truthfulness as we think we are. So don't rely on that completely, right? You might have some notes on that, but just be careful in relying on that completely to determine someone's credibility. Motive to falsify. So does anyone have a reason to lie? Would it benefit them to lie? And I've had that situation come up in a more innocent context with witnesses that first said, you know, there's no work problems, nothing's going on here. And then I re-interviewed them when I received some more information. And then they admitted, well, I didn't speak up because I'm afraid of retaliation, right? So sometimes there's a motive to falsify for those more innocent reasons. Corroboration, this is a really big one. Is what they're saying consistent with what others are saying, or what the documentation supports? That can be a really huge factor for you. And then past record. So if someone, for example, has a past record of similar violations, it doesn't necessarily mean that they did it this time, but it could be evidence that we take into account. On the flip side, does the complainant have a past record of bringing false complaints, or complaints that are always found to be not supported, right? So these are things that we can all kind of take into account as a very holistic view of determining someone's credibility. All right, so let's talk about the burden of proof. So what is the standard that we're using as we are making our findings? So it's known as the preponderance of the evidence standard. So I know that's a big flowery term, but what that really just means is it more likely than not that the allegations are true? So we are not, and again, we're not in a criminal case. We're not having to prove it beyond a reasonable doubt or meet a higher standard of evidence. How the Civil Rights Department has referred to this is 50% plus a feather. So if you imagine kind of two scales on each side, if you have the scale tip just slightly one way or the other, then you want to come to your finding, you know, that the evidence supports that it did or did not happen. So it's a much lower standard for employers. So be aware of that, that you do not have to prove it beyond a reasonable doubt. All right, now when it comes to preparing our investigation report, this is a really important step in the process. And the way that I always envision writing it is if we have a lawsuit or a dispute down the road, and if someone goes and reads it, are they going to understand all of the issues and how I came to my conclusions, right? Because they don't necessarily know these employees, they don't know the background. And so we should really, again, write it to tell a story. So we should be very clear on what the allegations are, who are the interviewees, so name, dates, times, locations of interview, that can all be really helpful. What was the information that they said in their interview? Any documents or other surveillance records that you took into account. And then we want to ultimately have our findings in the report. And again, these are factual findings. They're not legal conclusions. So it's what happened and did we find that there's any violation of policy that happened. And we want to use objective factual language, right? We want to point to witnesses were consistent in saying XYZ, the surveillance reflected this, right? So point to those factors. We don't want to just have a blanket statement that we found that harassment occurred without any sort of supporting evidence behind that. And then for each allegation, you want to make sure that you have a separate finding for each one and then address why you found the way you did. So it should really be one of the following. Founded mean that it's more likely than not it's true, right? The allegation is substantiated. There's enough evidence to say more likely than not this did happen. Unfounded is the opposite. More likely than not this is untrue. And then the last one is inconclusive, meaning there's not enough evidence to determine one way or the other. But you want to try to avoid these types of findings if possible. And the reason is they can subject you to scrutiny down the road because someone might say, well, did you really interview all of the potential witnesses? Did you really look at all of the documentation? Was there anything else you could have looked at to come to a finding, right? And that standard, again, is just 50% plus a feather. So even if you're feeling like you're a little bit on the fence, sleep on it. If there's someone that's, part of your HR or management team that you can kind of talk to and flesh, through issues with, do that. And then just revisit those interview summaries too. That can be really helpful that you find, oh, actually on this issue, witnesses were consistent, right? Or looking at the documentation again, another time can often help you fall into the founded or unfounded bucket. And then finally, as I mentioned at the beginning, really the whole point of your workplace investigation is to come to prompt corrective action if there are policy violations that are happening. So if you find that there are violations, then California law requires you to take appropriate remedial steps. And that is always going to depend on what the severity was of the issue and also the number of violations, right? Is this a pattern? Is it a one-time thing? And that can look very different if someone, is making a joke that's not appropriate for work, a one-time joke, versus someone that is consistently, physically touching someone in an inappropriate way. You're going to probably have two very different responses to those things. So we're going to want to take a look at what our policies say and also make sure that we are consistent in our disciplinary action. So if you ever had that issue in the past, how was it addressed? And then when it comes to corrective action, we really have a variety of options here. Just like with any other disciplinary action issue, right? We could do a verbal or written warning. Maybe we suspend someone or demote someone if it's more serious. We really want to send a message, place them on a performance improvement plan. Or we might say, you know what, this person cannot be in our workplace with the conduct that they've done. We have to end employment. We have to terminate them. Or it can also just be a combination of these things. So you might have some disciplinary action, but you might have them work with a coach, especially if it's more like employee relations types issues, or they're, not being as effective as they can as a leader. They might have some coaching, might do some additional harassment prevention training, right? Make sure they're really clear on all of the legal protections and requirements. And when you're unsure, you always have the option of consulting legal counsel, right? Especially when there are findings of discrimination, harassment, or retaliation. All right, so we are coming close to the end of our hour here. So I want to go over some employer takeaways and then some additional resources for you. So just kind of to recap, pay attention to those different investigation triggers, not just those formal complaints, but things we observe, anonymous complaints, right? We want to make sure that we are prompt in our response, get that investigation going, and select the appropriate investigator, whether that's someone internally at your company or whether you make the judgment call to bring in a third party. Make sure that you are documenting and summarizing your findings throughout the process. And then, of course, take meaningful corrective action. And also a really important tip is follow up, right? After you've conducted your investigation, you've engaged in corrective action, make sure you're checking in with employees to see that it was actually effective, right? And that behavior is not continuing. Now, if you do want to continue mastering your workplace investigation skills and you do need some more of that practical hands-on experience, we do have a special event on December 3rd and 4th that CEA is hosting. And this is a 2-day series where we are going to expand on all of these investigatory practices and go over some practical exercises and group discussions so you can practice, coming to your findings, making credibility assessments. So it is a no judgment course. And at the end, we do provide a training certificate. So we have the bit.ly link for you there. And then here's just some end of year reminders. Make sure you have your 2026 labor law poster ordered, and then get those employee handbooks updated based on the new laws. And if you trained for harassment prevention in 2023, you will be due by the end of 2025. And then I also want to remind you, please call into that HR hotline. I want to give a big thanks to the San Bernardino County Workforce Development Board for sponsoring this event today, sponsoring the hotline. So please take advantage, call in. We are available Monday through Friday from 8 to 5. And with that, I will turn it back over to Anna to close us out and see if Carmela and Angelica have any last words they would like to address.
Anything from your team besides to register for the next training coming up on December 17th. Yeah, I do want to draw your attention to the chat. If you did not see the little flurry of activity in the last couple of minutes, please open up your chat box so that you have a little visual reference. But we do have that next training if you weren't with us at the beginning. December 17th is going to be the next complimentary training sponsored by our partners over at San Bernardino. Communicate like a leader. It's a wonderful training. So definitely register for that. And then as Juliana mentioned, we do have through CEA our Mastering Workplace Investigations series. This is a brand new training. It is fantastic. And that is coming up on December 3rd and 4th. So the link is there as well. And what else? Let's see. Oh, and then I did put a copy or a link, excuse me, of the survey that is on the screen as well. So you can either scan that QR code, you can click on that SurveyMonkey link, and that is 5 brief questions. But this is also how you suggest topics that you'd like to see in the future. And then I do have a few questions about the recording. So yes, the recording gets sent over to our partners over at San Bernardino. They typically pretty quickly, they have an amazing team, get it up on their YouTube channel. So make sure you are active there. And since I do have a few people unable to download from Zoom, I know sometimes Zoom is very tricky with security and what your computer or device will allow you to download from Zoom. So either I can send it out or Carmela and their team will send it out. So we will figure that out, but you will get a copy of the PDF slide deck by end of day today. And then if you are joining us for continuing education credits, those are on the screen. I'm also dropping them in the chat for your convenience, but your HRCI code is 720234, SHRM code today 25-95K64. Please always reach out to us, ceainfo@employers.org, or you can call into that complimentary HR hotline, and we're more than happy to guide you on what to do with those codes to be eligible for certification. With that, I again want to thank Juliana and Mary for their time today. Thank you, Carmela and Angelica and your entire teams for all that you do for employers in your area. And then thank you all, of course, for coming and being so engaged and participating. And hopefully you got a lot out of today. And maybe we'll see you on that new training that we're hosting in December. So look for an email from us with the PDFs and then a link to that YouTube channel. And we'll see you again in December. Thank you all.
Thank you.
Thank you, everybody.
Bye.